Before we start the question answer session, joining Vinay and Daniel on the panel is Neil Shah. Neil is the managing director of DK. He has over 15 years experience in the commercial property sector. DK is a boutique real estate advisor with an end-to-end service from advice through to execution. They help with purchase, asset management, and disposals. Examples include warehouses, supermarkets, dark kitchens, shopping centers, high street shops, and nursing homes. They source investments from a wide network built over 5 decades of being in the market. Recent sources of attractive property deals for their clients include receivership sales, private treaty, and local authority tenders. So welcome, Neil. Okay, if I may start off with a question for either Daniel or Vinay, please. Basically, where we have a tenant who is struggling to pay rent and either he's agreed or he's agreeing to say, I will want to defer my rent payment and pay some rent in arrears, etc., given that he has been on furlough or going to be made redundant at some point shortly or whatever. And then obviously applying for benefits, which would mean that they probably end up being able to pay the following month's rents. If the tenancy has a 6-month break clause, what should be the landlord's sort of optionality here? Because obviously, instead of dipping into savings for them to pay for the mortgage interest, etc., what should the landlords be doing? I think you covered a little bit of deferring and so on, but perhaps just
well, I think the range of options open to the landlord there are either A, sort of agree to defer the rent for a period and say, well, look, let's have this recoverable in the future. You've mentioned that their tenant is likely to be able to pay it back in the future. So at the moment, given how difficult it might be to let something, I think as long as there's a written agreement, like I talked about, that covers when that rent will be payable by, when this arrears will be payable, and as long as the landlord can afford to do this by covering the mortgage in the meantime, then I think deferring it might be the order of the day. Deferring it might be the commercial option, because that way at least you keep a tenant in the property who's going to be paying the rent at some stage, we think. The alternative, if there is a break clause, and obviously it depends very much on the circumstances of the tenancy, and it depends on the type of tenancy, the type of how long they've been there, and all the various notices and stuff, but you can seek possession of the property. It won't be until quite a while from now before it's going to be possible to recover possession of the property. Any notice served now has got to be at least 3 months long, so it's not going to be until July, August, September that notice expires, and it's not going to. And then that's when you have to start the court process. And when you start that court process, you're going to start incurring court costs, and also it's going to take months. I mean, when we come back from when the courts reopen again from lockdown, so it could well be February, March before you're looking at getting back possession of the property.
Sure.
I would just make one point that as practitioners, we always get a situation where you do need a good email thread. You need to make sure that we are presented, the lawyers are presented with good evidence of how you've done this, because if you are going to go and seek arrears, then we would need to show to the judge how you've done this, because I've come to court and, it's landlord has said this and landlord has let me off this way, and we know where to prove that, and the judge is stuck with these arguments. So whatever you do, make sure that
right. Yeah. Can I, as the other side of the equation is, if this does happen and there is an agreement to defer rental or whatever, but the tenant then decides to end the tenancy agreement before paying the rent arrears, and then decides not to pay, what are the options in this situation? Because obviously if the tenant moves out of the property, the other problem is you don't know where to locate that tenant if he's moved on somewhere.
Well, there's the legal answer to that question, which is as long as you have clearly set out in writing what the obligations are with regards to this deferred rent, it will remain a live debt, and as long as you enforce it within the limitation period, it will be something that you'll be able to recover from the tenant. And then there's the pragmatic answer, which is, are you going to be able to find this tenant? Are they going to have enough money to pay you any arrears if you sue them? Because that's what you have to do. You have to sue them and take sort of a small claim against them. Is it going to be worth doing in any event? Because if you instruct a solicitor in a small claim and the amount of money which is at issue is less than £10,000, you can only recover very, very, very limited amounts in respect of any legal costs. So it's usually like court fees and maybe £65 for service of notices. So you might well end up spending more than you're going to get back. So I think the legal point, as I say, is that it remains a live debt and it's recoverable. Practically, you'd have to think very commercially and take a commercial decision as to what the right thing to do was.
Okay, thank you. Chetan?
Yep. So this question is either to Daniel or Vinay. Where you have an assured short-hold tenancy which had 2 tenants on it, the assured short-hold tenancy has expired. One tenant has served notice that they will vacate, but the other tenant doesn't want to vacate. Has the tenancy ended? Or if it has not ended, do you need to serve the remaining tenant with a Section 21 notice? And the second part to that question is, if the tenants are not paying any rent, can you hold both the tenants, including the tenant who's vacated or served notice to vacate, and the remaining tenant for the outstanding rent?
I think the easiest thing to do would be to deal with that backwards. The second part of it is that tenants are joint. It depends on what the agreement says, but the norm, by far the norm, is that tenants are jointly and severally liable for the rent on an assured short-hold tenancy. So if they're joint tenants, they have one tenancy with their 2 names on it, then the landlord is at liberty to go to either tenant and recover all of the rent. So you can decide, I want all of the rent from one of the tenants. The first part of the question is a little bit more complicated because it's about, so if one tenant serves notice saying that they want to leave, but the other tenant doesn't, it will depend potentially on what the tenancy agreement says about break clauses, but also it's going to be a question that the other tenant is simply not going to go, and then you won't be able to evict them without a court order because of the Protection from Eviction Act 1977, and they will say, and then there's kind of very broad protection. It sort of doesn't really admit of, angles and options. It's just sort of, you can't really kick somebody out of their house without a court order if it's the house where they live, and that's about the long and short of it. So if in that situation, I would say serve a section, if you're able to, and if its timing's right, serve a Section 21 notice on the property on both tenants, save yourself the trouble, because that way you've got a clear route to a mandatory order for possession, and you will get possession back at the end of that Section 21 process, providing that you've done everything right. And because the risk otherwise is that you'll get into a whole situation about where the one tenant is entitled to end a tenancy on behalf of his co-tenant, which it might say in the tenancy agreement might be silent on, and either way is going to be covered by the Protection from Eviction Act, and it's going to be more difficult. So yeah, just serve Section 21 notices and then deal with the money separately would be my advice in that situation.
On the back of that, I would say that sometimes you have a sort of twist, sort of on its head. You have the remaining tenant wanting to replace the exiting tenant, and I would suggest that you always get a brand new tenancy and start again. So this is certainly a way of mitigating the position if you were to have one remaining and one exiting. So my view on this is always to try and keep this in proportion. What you want to try and do is to have the tenant who's paying, keep them in, and certainly try and replace the other tenants. But again, try and get a brand new tenancy for that.
Thank you. Nirmal?
Yeah, guys, just one thing to come back on. So you set the quiz out right at the onset. No one got the answer right on the audience. Everyone thought it was a tenancy agreement. So there you go. Okay, just a question actually to Neil. What steps can one take to get commercial landlords to recover or get someone to pay up the rent, which is 1 quarter overdue? I'm assuming this is with the COVID-19 March 26th timeline onwards period.
Thanks. So under the COVID regulations brought in by the government on the 25th of March, the government have asked for a moratorium where no landlord can take any action until the 30th of June. So a bit like the residential tenants where there's a 3-month order. For commercial tenants, no commercial tenants can take any action for eviction or take any bankruptcy proceedings against the tenant up to 30th of June. It remains to be seen if the government will extend that because the next quarter rent is due on the 24th of June, which is only in about 6-7 days time. So we'll get to see, but at present, you have to wait till the 1st of July.
Okay, and I'm just following on from that. Commercial tenants at the moment are insisting on a rent-free period. So I'm assuming what you said there, which is that 3-month gap, is that what is the rent-free period for them?
No, the rent is payable, it's due and payable, it's accruing, and it's in arrears. And I think Daniel covered the question that there's no, in Daniel's presentation, there's no legislation that writes that rent off. It's a matter for the landlord and the tenant to agree something that's mutually acceptable. But in the absence of that agreement, the rent still remains outstanding.
Yeah, the charity that I act for owns a number of commercial properties, and so in my position as commercial landlord, we've agreed some deferrals of rent, and that rent will be due and payable, and we've agreed with the tenants that they will they'll pay it back on a payment plan which we've got them to sign up to over the course of their lease. So it remains owing. It's just we're going to let them have, one of them is, for example, a hairdresser, so they haven't had any money in since March. So we're going to let them not pay any rent for this period, and then they pay an increased rent for a specific period, and it'll all come out in the wash.
I would just make the point that if you are to use your rent deposit deed, be very, very careful. If you're going to siphon money off from the rent deposit deed, make sure that you have an agreement in place where you either put that money back over a period of time, or you have some sort of an agreement or a side agreement, again by deed, that actually alters that situation. We are going to get ourselves into a terrible mess when deposit deeds are raided during this time. So be very wary of that obvious place to look for rent.
Okay. I think this question for Vinay, I think you might have dealt with part of this question, and it was basically, would it be advisable to have landlord insurance, and would this cover legal costs in the event of a dispute and going into court? And I think you said at somewhere earlier in the presentation, you should literally always tick the legal cover box, and it doesn't cost much. So it's a bit of a repetition, but the first bit is basically, should you have the landlord insurance
I would
cover?
just make one very important point. There are very cheap insurances. It's like being sold mortgage insurance by the mortgage provider. It's the worst idea. So if you're going to shop around for insurance, get a proper dedicated insurance for it. Do not be sold it by any third party. That's your first point. Your second point, this is where I would make, is the rent protection scheme. And these are sometimes done by estate agents. They're not really rent protection. What they do is we will protect the rent if you pay me a high commission, and we will instruct our own solicitor, our own cost to get rid of the tenant. It is a slow process because, of course, the estate agent has no incentive. You know, he's been paid the money. I would go for a proper scheme whereby it is actually a proper insured scheme. But again, I would really recommend these really bespoke, these standard policies, DAS, very good sort of insurance policies, which are dedicated insurance policies. And what happens is you then get a very good solicitor on their panel who then deals with it. And that is the way I think is the most efficient way of dealing with insurance.
And just a follow-on question, I think somebody just asked about landlord insurance. And basically, I think the problem they're having is trying to get anybody to answer them. And there's been no response. And I presume part of this is relating to people not being in the office or still working not from home, etc. but the answer should be perseverance, I guess. This is a DAS protected insurance somebody's asking about, and it's purely that. So, yeah.
Don't forget there are freebies around. You know, you've got AA. You should have legal cover. There's lots of insurances which have these sort of called ancillary side-ons, which have free legal help, and they are very, very good. And I would suggest that people always have these things if they have that within the policy. So make sure you use it.
Mm-hmm. Thank you. Chetan?
Sorry, yep. So this is for Daniel. Daniel, if the tenants are on universal credit, and obviously they're not paying their rent, but there is a rent guarantor, can you pursue the guarantor?
Yes, I mean, that's the value of the guarantor. You need to look at your guarantor deed and what they've signed on the tenancy agreement, because ultimately it's a contractual arrangement that you have with this guarantor. And often for people on benefits, it might be that it's a council guarantee deed or something. You need to just look at the agreement, but probably yes. It's not necessarily the case that you would have to end the tenancy before you can go after the guarantor. It's often the case that you can kind of do it mid-flow, but it depends on the written agreement. It's not like a specific legislative regime or anything. It's just what you've agreed with that guarantor. If you're drafting a guarantee agreement, then make sure that you can cover any rent at any time.
And on the back of that, just a question that comes to mind. If you're dealing with any agreement with either a commercial or a residential tenant, where you do have guarantors and you're agreeing to delay the recovery of rent, are you under an obligation to notify the guarantor of your discussions with the tenant?
That's an interesting question. I wouldn't have thought that you were. I would have thought that your only duty, I mean, it's a contractual arrangement between you and the guarantor. And if your guarantor arrangement says the landlord agrees and undertakes to email within 7 working days or something, then obviously you've got a contractual obligation. But there's whether there's a freestanding obligation to notify a guarantor that you come to an arrangement with the tenant, I don't think that there is. I think that you would only really be obliged to speak to a guarantor if and to the extent that you need to engage their guarantee agreement. And if you're deferring the rent with the tenant, then the expectation is that you'll have the rent paid in full by the tenant at the end of whatever agreement you've reached with them for a deferral. And so the guarantor's guarantee agreement will not be engaged.
Can I just come in there? So I've seen some of these guarantee agreements before, and they have two elements to them. One is the guarantee and the other is indemnity. So the difference between these two, and this probably may answer some of that question, is that the guarantee is the guaranteed part of the effectively the rent and what's due. The indemnity is slightly different, because what you're doing is if there's any legal costs incurred in recovery, any issues concerning the delinquent payer, that is all covered within that. And whatever arrangements you come to with the tenant, as long as it's not beyond the remit of the actual agreement reached, which is the short-term tenancy agreement, you should be fine.
Okay, thank you. Nirmal?
Yeah, again, I think I'll go back to Daniel for this one. Do we need something in writing that the tenant has actually received the gas certificate? And also, is it the estate agent who is looking after the property? Is it his responsibility to have this on record?
So in answer to the first question, you don't specifically need, there's no legislative requirement to say that you've got something in writing confirming when it was served. If you do, so if you do it by email and then you print out the email, then that's a very, very sensible thing to do. And you know, as a solicitor, it's always better to have written records of things, and it's always better in particular. If there's ever a dispute about it, then as soon as you produce that email saying, look, here is the email dated 21st of whenever with the gas safety certificate attached, then that dispute comes to an end. As to whose responsibility it is, lots of people have got different contracts with their agents and with their estate agents as to what level of service they'll be getting from their estate agent. And estate agent contracts are usually quite enthusiastic about limiting liability. Whether or not they're actually entitled to is a matter for another seminar, and the Consumer Rights Act and various different things. But I think it's a bit of a missed point to say who's responsible for this. I think as a landlord, you've got to make sure before the tenants move in, or on the day that the tenants move in, that you've got a copy of something showing that they've been served with a gas safety certificate. Because ultimately, at the end of the tenancy, when there's any problems if you haven't served it, it's your flat and it's your problem with rent, and it's your house or your premises. It's your problem, bluntly. And then you might, if there are losses that are incurred, the managing agent is not going to have any greater right than you are to get possession of that property if the gas safety certificate isn't properly in place. And then you can sue the estate agent for damages to say, look, you've messed this up and you've caused problems for me. And you might get some money from them and you might not, and it would depend on what the contract said. But you would still have this problem with this tenant. Although obviously all of this could change tomorrow, because that case is coming through the Court of Appeal tomorrow. So we're all very excited to see what the Court of Appeal has to say intra Carol. But for the moment, I would say, yeah, the legal answer is it depends on your contract with your estate agent. The practical answer is, as a landlord, make sure that you have proof that it was served in your possession.
Okay, thanks.
Question for Vinay. Can you pass on the court costs and solicitors' costs and other fees if there is a legal action against the tenant, or do you have to get the costs awarded to you if you're obviously going to court?
So I'm going to give you a lawyer's answer. So yes, you can have your costs, but unfortunately not all of them. So as with everything, the costs are limited and they're fixed costs, and the courts are quite they're not so willing to give all the costs. So there are two types of costs. There's your own costs, which is your solicitor's costs. So assume you have a cost of £1,000, you will be given a small proportion of those costs which are recoverable. So whatever happens, you're going to be at a loss. And you've got to have a balancing exercise, a cost-benefit analysis of how you recover your rent as well as the deficiency in costs. So that is the reality.
So the specific figure that you can recover at the moment on Section 21 proceedings is £424.50, I think, because it's £355 for the court fee, and then you're entitled to a further £69.50 in respect of your solicitor's costs. And your solicitor's costs are obviously going to be quite a lot more than £69.50, or at least they are if you instruct us. So you can't get all of your costs. You will end up with a substantial deficit between what you can recover and what you're going to have to pay out.
Mm-hmm.
Okay, so this question is for Neil. Are there any special arrangements for obtaining possession of commercial properties that are let for use as a restaurant? Are you aware of any special requirements?
No, there are not any special arrangements. It all depends on the terms of the commercial lease that they've occupied under.
Okay, yep, I think that's fine. Yeah, Neville?
No.
I've got one here. If a tenant, sorry, I'll put it out to Daniel or Vinay. If a tenant does not pay rent and you subsequently miss out on the mortgage payments, and if your lender then repossesses the house, who picks up the cost of evicting the tenant?
Sorry, Vinay, do you want to? Or?
Yeah. So in repossession actions, effectively you have a contractual obligation to the mortgage company. Ultimately, the mortgage company, when they take possession, they are something called mortgagees in possession. So effectively, they are in your shoes as owners. Now, you've signed a lovely form called the mortgage deed, and that gives them effectively a blank check to say they can spend as much as your money in recovering that possession, and that is all going to go on your bill, and that bill is going to be deducted from the sale of the house. So ultimately, you are going to pay, and pay through the nose you will, and all of those costs, both in terms of the repossession costs which have led up to this, but also don't forget, the minute you default, all that thick, big, thick pages and pages of mortgage deeds that you signed all kick in, and all the costs, penalties, interest, all of that comes in. So beware of that scenario, because it is a very, very costly. But of course, as with everything, we're a culture that has an opportunity written all over it. So there's opportunities out there when, of course, as I said to you at the beginning, mortgage repossessions are beginning to rise, and they will rise and rise. So there are, as I said, opportunities out there, but they will mean that people will scramble.
Mm-hmm. Okay.
Thanks. Remit?
Yep. Okay. Just a question for Daniel and Vinay, please. I think you partly answered this question before. Where you have a Section 21 notice served to joint tenants, obviously the joint tenants are all jointly and severally, let's assume they're jointly and severally liable. Do they still have to pay the whole rent? Or if one person's staying in there, the other one's gone, is the guy who's remaining has to pay the whole of the rent, or you have to go after the other tenant as well? It's the same sort of question as before, I think.
So it depends on the drafting of your assured short-hold tenancy, but the vast majority of them, and certainly all the ones done by sensible people, will be that the tenants are jointly and severally liable. And the effect of that is that it's up to you, basically, what percentage of the rent you go for from what percentage of the tenants. I mean, the starting point would be that you would just say, I want all of it, and it's up to you how you get it to me, but I want it by this period. If you have to pursue them through proceedings, then what you would do is you would make a claim against the three of them jointly and severally. Sorry, I just assumed that there were three of them for some reason. Say there were three, you would make a claim against all three jointly and severally, and then there would be a joint and several enforcement against them, and you would get an order jointly and severally against them. And then once you had that court order saying that all three of them somehow between them had to pay you X amount of money, it would then be up to you how you enforced that against them and what options you took against each one. The fact that there might be a Section 21 notice in regards to tenancy is a bit of a red herring, or if one of the tenants or all of the tenants have served notice that they wish to end the tenancy, again, it's a bit of a red herring. The obligations under the tenancy, so your obligations to repair, their obligations to pay rent, your obligations to quiet enjoyment, their obligations to look after the place, are there 100% until the tenancy comes to an end, and then they cease. If there's notice has been served, and then as Vinay said, because the best thing to do if there's any sort of switching around is to just end that tenancy and get everyone to sign up to a new tenancy and say that we'll just have a totally different, fresh tenancy. Because when you sort of start swapping people out, suddenly you get into this situation where the courts could find that the tenancy that you have is not the tenancy that you thought you had. The written document, the tenancy agreement, is obviously very, very, very strong evidence as to what the situation is with the tenancy, but it's not the absolute last word. So if you write something on a tenancy agreement but it's clear that that's not the case, the court will go with what the sort of facts are, following Street and Mountford, lies and lies. And so, yeah, sorry, well, we were talking about there being jointly and severally liable. Yes.
Yeah. Okay, thank you. Jathan?
Yep. So I'm going to make some assumptions with this question that's been asked, because I'm not sure if all the details fit into the circumstances. I'll open it to the whole panel. Where you have a commercial property and the tenant, so let's assume that the tenant is an individual as opposed to a company. The tenant has entered into a joint venture with a third party who is now running the place. So I'm not sure what they mean by joint venture, but let's say that someone else has come in and is running the shop. Who's liable for the missing rent? And can the landlord evict the person to whom it has been sublet, and the subletting has happened without consent? Does that make sense?
Yeah. So the person, I'm sorry, I'm slightly struggling to follow. Is that, I don't know.
It's a difficult question because there are too many questions that we lawyers like to ask.
Yeah, I mean, it's not from the end. Can you end a subletting? You have a contractual relationship with the person who let the tenancy from you. If they sublet it to somebody else without your knowledge, then the person beneath them only gets their right from your tenant. So if you end your tenancy with your tenant, then any tenancies beneath that cease to exist because the tenancy by which they had a right to be in the property ceases to exist. So you can then evict people by evicting. But then there's problems where if you knew about the subletting and let it happen, maybe even took some money off them, then you might create a new tenancy with this new tenant, and then it becomes murky. So it comes back to what Vinay said, which is just sort things out, get a new tenancy, make everything clear.
Okay, so sorry, go
So
on.
I can add to that to say, based on the assumptions that you made on your question, it's probably a good idea to start saying what was the basis of the occupation. So who is the tenant and who is the named person on that lease? And then it will be up to the terms of those lease that will determine how you evict or get rid of the so-called joint venture, third party, subtenant, or whatever that person is. And it'll be that basis of occupation that will determine it, as David put it.
So I think really the first thing that people need to do is, when a situation like that arises, is to seek advice.
Yeah.
Because you could be entering into a lot more complications just by accepting rent.
So yeah, as I was saying about residential tenancies, but it's even more true with commercial tenancies. You can very easily create a tenancy that you haven't intended to, and you can find yourself where the documents say one thing, but then they've been sort of superseded by events. And with a commercial tenancy, you could end up finding yourself having created a tenancy which is protected under the Landlord and Tenant Act 1954, for those among us, where tenants in that commercial tenants have a right to just keep extending their tenancy subject to various exceptions, and it can become very complicated and expensive without meaning to. So take advice. Come to a solicitor. We're very reasonably priced.
Rabbit?
It's Nirmal, I think.
Nirmal, sorry. Yeah.
Vinay, I'm just going to go back to the rent deposit part that you were talking about, where if you have a written agreement with your tenants and you access the rent deposit because rent is not being paid, is that okay? Is that written agreement good to have to be able to then access those funds?
It's a bit more complicated than that, because what you're doing is effectively raiding a sum of money that you will need later, and you'll need it to effectively sue the tenant later if they don't yield up properly, if they leave it in a defective state. So you do need that pot of money, and usually what we recommend is that you can raid that money. But you can do it on a short-term basis, and then you can come to an agreement, but it must be as effectively like a separate deed, a separate agreement, to say that money will come back into that pot, and then that deed will effectively be reinstated. But what you don't want to do is to have some sort of vague agreement as to what was going to happen to the repayment of the rent, because the tenant may say, well, actually, he let me off the rent in terms of the deed, and the deed will remain effectively all of it was at the beginning of the tenancy. So be very careful messing around with the rent deposit. If you are determined to make use of that money, make sure it's formally dealt with in two ways. One is when it's going to be repaid back, and secondly, to reinstate that money at a certain period of time.
Okay.
I think this may be a question for all of you, but it's basically, why do estate agents advise against going down the Section 8 evictions route, even when rents are more than 2 months outstanding? And the second bit of the question is, don't the courts have to give an eviction order if the rent is more than 2 months outstanding?
So there's two problems with Section 8. Is firstly, the tenant will, as opposed to Section 21 proceedings, which is why estate agents and solicitors will often recommend go for Section 21, even though there is arrears of rent. The first problem is having to actually prove your case. So you say that the tenant is in a 2 months arrears of rent, they will come back because they will go to the council housing office, and the council will say to them, these are the defences that you have, and so the tenant will come back with counterclaims, and their counterclaims will be about disrepair to the property, about works which they've asked to be done but which haven't been done, about any breaches of any issues with the tenancy that you have committed as landlord, and they will say, because of these breaches, I am not actually in 2 months arrears of rent because the landlord owes me this money in return. Now, that might well be nonsense, but the court doesn't know that. So the court has to give a direction for parties to put statements in, to put in rent statements, to put in full details of the history of the ownership of the tenancy and the arrears, give the tenant a chance to put in all of their comments about disrepair and so on, and then has to list a trial. So one, there's that problem, the tenant's going to defend it, which brings us on to the second issue, which is that even if you get to a successful order, and you probably will, because these defences are just something that tenants come out with, and if you manage things properly and if your solicitor's done their job, you probably still will get the order, but it'll be months. Because of the fact that you have to have a full trial, a court's got to set aside a whole morning to deal with this, as opposed to Section 21 proceedings, which can be dealt with on the papers and can literally just be done in the post, provided that everything is in place. So it's much, much longer. And then because it's a whole morning, you've got to go down there with your solicitor, who's prepared your statement, who's gone to the directions hearing, who's got everything ready for this case, and he's got to prepare for the case and then argue it, and there's a lot of costs involved.
Yeah.
And it's far more expensive than Section 21 because of the amount of additional evidence and work that has to be put in. And then because of and that extra expense, like we talked about when Vinny said about the costs, that there are limits on what you're going to get back from a tenant. One, the court is not going to say you will have every single penny of your costs repaid to you. They're going to knock you down a little bit. Two, if you get an order for costs to get for £10,000-12,000 against somebody who's on universal credit, it's not realistic to expect you're going to see any of that money in any event. Like whatever order the court might make, if they're on a very, very limited income and have no assets, then they're going to get a payment plan where they give you £18 a month or something, and then your grandchildren might eventually see the debt paid off the estate. So all of those reasons are why it's almost always, and similarly with the arrears of rent, you'll get an order at the end of the Section 8 proceedings and the judge will say, I'm satisfied that they ought to pay 4 months back rent, costs of £8,000, total bill. And you have these things where you've got, because obviously I've done Section 8 hearings and I've got to the end of them and I've handed this order to someone who's on universal credit and is living in rented accommodation, saying that they've got to pay like £22,375.80. And it's like, yeah, what? Where's that going to come from? Who's going to pay that? Like, and so it's just written off money, basically. If you go down Section 21, and it will be a lot quicker, a lot less costly, and also it's mandatory, so you might even lose at trial. The judge might say, you know what, you're right, actually, the landlord should have put in a new shower or should have done this or that or other thing. And so the damages for that bring it down below the mandatory possession level. And on that basis, it's my discretion as to whether or not I grant possession of this property, and I'm not going to. So then you haven't got possession and you spent over a year on this. And obviously, again, your solicitor will make sure that doesn't happen if they've organised the case properly. But litigation is always a risk. There's always a risk that a judge will be in a really terrible mood that day. Whereas it's Section 21, provided that you filled in everything correctly and got the documents lined up, you'll get possession. So that's why.
Great, thank you. Chetan?
So I'll initially point this to Neil, and then perhaps Daniel and Vinay, you can step in if need be. So Neil, the question is, what steps can you take outside COVID-19 regulations and interference if rent for commercial property is not being paid? Can you change the locks?
Well, the first starting point, again, like last time, is you need to look at your lease, because most commercial leases will have a provision after a certain period of 14 or 21 days, you can take action. It depends if you want the property back, which is from what I'm gathering from your question, because they asked you want to change the locks. You have to serve something called a Section 146 notice, which is a notice to forfeit the lease. At which point, depending on what the lease says, there should be a clause for peaceful re-entry, which is you go in very early morning or very late at night and you so-called change the locks. But there's another way of obtaining your arrears, which is under CRA, it's a commercial rent arrears advisory service. You send a bailiff who will try and repossess some goods and get some recovery of your rents. That's another option. But again, as Daniel will point out, you need to look at a lease, because it depends if your tenant is actually the occupier, or do they have subtenants who are actually occupying, who will have potentially rights? So in a nutshell, or in short, it depends on the lease, but these are 2 or 3 of your options you can take into account.
Okay. Daniel, Vinay, anything you want to add to that?
Don't forget one really important thing, and that is that if you have taken walk-in possession and peaceful re-entry, that the tenant has the right to set aside that section 146. And you know, it's a long period, and you've got to wait. And you've got to wait around until the tenant decides that he wants to come back in. And many a time, I've had a situation the tenants will sit back and wait until something happens before they actually make their Section 146 application. So the landlord's stuck with his property with no rent coming in. So practically speaking, it's not the best scenario, because ultimately you can mitigate the position by getting another tenant in, but you've got to wait the requisite period if the tenant decides he wants to set aside the Section 146 and go back in. Of course, if he does make that application, he's got to pay all the costs, he's got to pay the rental arrears up to date. But will that happen? We don't know, but you've got to wait the requisite period. That's the problem.
Right.
Vinay is very right, because the landlord will be in limbo and the tenant's got a one-way bet. The landlord could be waiting for, say, 2-3 months. He then goes and finds another tenant to come in, a prospective tenant. The old tenant finds out, and then he comes back. And if he doesn't come back, then the landlord's lost the rent in that time.
So presumably, I'm saying obviously the landlord sitting there without rent being paid. So perhaps making an application to the court for possession would probably be the best option, rather than taking walk-in possession and then having the tenant serve seeking relief from forfeiture. Yep.
Right. And you got the practical problem of rates. So if you take the possession, you're liable for empty rates on commercial buildings, which can be quite hefty. If you don't, then whilst you're taking action in court, the tenant's still liable for the arrears.
Okay, thank you.
Good point.
Nirmal?
I think it's the last question I've got at the moment, which is to Daniel. Can you serve your gas safety certificate by email?
Yes.
Okay.
Yes, except there's 2 different situations for gas safety certificates. There's one where there's a relevant gas appliance in the house. So if, for example, the house has got a gas cooker or a gas boiler and it's all part of the same house, then you've got to serve it to them somehow. Email is fine. Email constitutes, it's not covered by the archaic rules of service that court proceedings are, and email is fine. If it's usually about HMOs, but if it's where there is a gas appliance that's kind of within part of the building, but not within the part of the property which is let on the tenancy, you don't necessarily have to serve it on the tenant. You just have to make it clearly displayed within the tenancy. But there's so much, I've had arguments about whether there's something being pinned to the inside of cupboard counts is clearly displayed, or whether it's pinned to the inside of the door of the bathroom is clearly displayed. And, you know, life's too short, just email it to them. It takes 5 minutes.
Okay, thanks.
I think this probably is my last question. I think there's one more which Chetan will probably take after this. Can we serve a Section 21 notice when tenants are temporarily moved out for essential agreed repairs to property? That to Vinay and Daniel.
Yeah. It would depend on the circumstances of how you've agreed that they would temporarily move out for these essential works. But I assume that it would be, you said, look, can you just come out for a few days? We need to, do something that's going to take a couple of days where you need to be out. That should be, that doesn't change their position as tenants, and therefore it doesn't change whether or not you can serve notices on them. And so, yeah, with regards to practicalities of service, I'd suggest maybe handing it to them. So with notices, it's a bit more tricky as to, I mean, if it's going to be something that's going to be a few days, just wait, do it after. If it's going to be something that's a longer period, but the tenancy is still extant, then arrange to have it personally served on them. But yes, you can.
Just adding to that question, in terms of service of the notice, what do you mean by service? Is it enough to send it by post, or do you have to prove that the notice has been served if the tenant turns around and says, I never received it?
I've forgotten that not everyone knows Civil Procedure Rule 6 off by heart like we do. In these cases, service is sufficient by post is the starting point. You're absolutely welcome to put the letter to do a Section 21 notice by post or by recorded delivery. But there are two caveats to that. The first caveat is it might be that the tenancy agreement has something about notices. So often tenancy agreements will say a notice is validly served if it is X, and it will usually be for the landlord dropped off with the estate agent and for the tenant sent to the property. But you must make sure that you comply with that. If it says something other than X and you do X, then you might be in breach of that notice requirement. But secondly, as you say, Chetan, if there's any possibility, if you think the tenant's going to be any trouble whatsoever, then they might well say it never came in the post, and then you get into one of these arguments that I really despise about like the technicalities of the service and whether it's compliant with Section 196 of the Law of the Act 1925 and whether that was compliant with the Civil Procedure Rule. And it's for the sake of the cost of having somebody go round to the property and then sign a statement dropping it off at the property. I wouldn't say that you need necessarily to hand it to the tenant unless it's a slightly more quirky situation where they're not in the property, like Rumit mentioned. But if they're just living in the property, have someone go round, put it through the letterbox, sign a statement of service, and then there can be no arguments. And we have our process servers do it, and we get them. I usually do it that way because it's just completely removes the possibility of argument, and it costs like £60, so might as well.
Yep, makes sense.
Thank you.
Okay.
Shall I take my last question?
Yes, please.
So, Daniel, again to you, where there's a guarantor and the guarantor keeps on referring to the rent deferral guidelines issued by the government and suggests that the landlord agrees to a rent payment holiday, and this is in relation to residential property, what can the landlord do? I think this has already been covered in your talk, just to refresh everyone's understanding of it.
I think, yeah, so there's kind of three different competing sort of issues there. You've got on the one hand the coronavirus guidelines, which ultimately are guidelines and nobody has to do anything that they say. If the guarantor is saying, well, why don't you take a mortgage holiday, you'll say, I don't want to, I'm not obliged to. A mortgage holiday is, as I mentioned in my talk, a mortgage holiday is not free. It will extend your mortgage term, and in the meantime you will still be accruing interest on your mortgage, so you will be paying for that. So you don't have to if you don't want to, and the guarantor can't make you, and the coronavirus doesn't affect the legal and contractual relations that there are between the tenant, the landlord and the guarantor. So get them to pay the money. I mean, then as we talked about in the talk, like deferrals might be a very commercial way of maintaining a tenant relationship and thinking about the practicalities of the commercialities, but like the starting point is that the legal relations are all the same as what they were previously. The guarantor should pay the money, the tenant should pay the money, and the coronavirus guidelines and the mortgage holiday opportunities don't affect that.
Okay. Thank you.
I will take a last question. Just seen one coming in. So this is going to be the last question. I think it's Vinay and Daniel, please. Does the landlord have the right to ask the tenant to prove that all the utility bills have been paid in full before they return the deposit?
I would look at the tenancy agreement, but yeah, probably, because the concern otherwise would be that would be a liability that would arise on the landlord. And you'd have no way of chasing down the tenant. So I think that would be a reasonable thing to ask, yeah.
On the back of that, as a matter of course, you'd go around and of course you'd check the property before there would be a handover. So ultimately, as part of the process of the handover exercise, you would check that the utilities have been paid up to date, and more importantly, that the place is good to go before you even consider returning the deposit. But in the end, you've got to go through the deposit scheme anyway. So whatever happens, that's your final.
Okay, Vinay and Daniel, you want to enlighten us with the answer to your poll, please? I think we said everybody thought tenants' agreements were the sort of answer. What is the answer and why?
Well, the document that's certainly been giving people the most trouble recently when recovering possession of properties is the humble gas safety certificate. You wouldn't expect it. You wouldn't even often think about it. A lot of people are surprised that I speak to landlords because they're surprised that they exist. But it might well now create effectively a tenancy for life if that's not in place. But everybody should be watching this space for Trecarrel and Routsfield tomorrow, which is terribly exciting in the Court of Appeal, and it might all change.
Right. Great. Thank you very much indeed. Well, before we finish, a very big thank you to Vinay and Daniel for the fantastic presentation, and also Neil for being on the panel, and all the panelists again. Very good lively discussion and a very informative discussion. I've seen so many comments coming in from people how they've learned something today, and it's been very helpful. So again, a very big thank you to all of you for giving us the time and presenting and being on the panel. So thank you again. I hope everybody has found the webinar very helpful. We have recorded this presentation, as I said early on. This will be put up on our YouTube channel and on Facebook, so please look out for that. Also, please see our poster with respect to helping the elderly and the vulnerable, those in isolation and key workers. If anybody needs any help, here's the number, please call us. If you require any further information from today's webinar or any of our older webinars that we've done, please call, SMS us, or even WhatsApp us on our helpline number. Our next webinar, as I mentioned before, is on Saturday, the 20th of June at 3:30. It is for the younger persons and their parents and anybody else actually who is interested in this. It's a guide to school entrance exams. I think it's extremely important, and it'll be very informative. So please register, and we look forward to welcoming you all. If you have any suggestions for future webinars, please email us at cat8webinars@gmail.com. Kilit, if you can, thank you. And here are our Facebook page, YouTube channel, and our Twitter handle. So all it leaves me to say is thank you very much to everybody for attending today. Be safe, stay alert, control the virus, and save lives. Goodbye.